But what you're telling me is, if it's possible that this prisoner has to go through the expungement process, and there are procedural bars from doing that, there is no remedy for him or her in order to secure their rights even 20 years from now. What you're basically saying is, simply because they've been previously convicted, they cannot seek prospective relief 20 years from now, unless they get an expungement. But if they're barred by for some procedural reason, they have no protection.
A few limiting principles on that, Your Honor. We certainly draw the distinction between a properly lodged as-applied challenge and what the plaintiff is trying to do here and make a facial challenge, a prospective claim in name only, which is really by way of a declaration, where he would want the entire law declared unconstitutional.
He might win. He might lose because it's a facial challenge. We'll find out. But the question you're saying is he is going to be barred.
Unless and until he is able to achieve a favorable termination.
How do you deal with Edwards? How do you deal with Edwards remanding for the prospective relief to change the disciplinary procedure?
So certainly the language in Edwards is ordinarily a prospective claim would be barred, would not be within the ambit of HEC. We're very comfortable with the ordinarily language because ordinarily does not mean always. And if there is ever a situation there where
the procedures that he was attacking were the same ones that he raised in his past disciplinary proceedings, so I don't know why Justice Scalia wouldn't have just ruled.
Well, as I understand, it was the date stamping procedures, and it was unclear in the case whether or not those date stamping procedures had actually been applied. And even if they had, Justice Scalia would say you apply the test, and it's either a thumbs up or thumbs down determination. And if it's outcome neutral and it wouldn't result in a disavowalment or a collateral attack, then that's okay. But in this particular circumstance, there can be no greater impugnment on the prior conviction than a declaration that the law was unconstitutional.
Didn't we say the opposite of what you're saying in Woolley? Woolley is this case, and we came to the opposite result from what you're advocating.
Woolley is pre-HEC abstention case by its own language.
It is pre-HEC. I mean, if HEC did not exist, the way we would do this is we would say we have this case, Woolley, and Woolley just decides this case. And then the question is, should we really take HEC to be sub silentio overruling Woolley?
I'd push back a little bit on that, Your Honor, because even now, Woolley's abstention case, which by its own term says it's conducting a jurisdictional analysis. Of course, HEC is different. We're trying to figure out if the elements of the cause of action are met. And so I would give the court the Skinner opinion, where you had Rooker-Feldman and you had HEC. And this court tackled the jurisdictional issue completely separate from HEC and said, well, he may not have an abstention problem under Woolley, but he's got a HEC problem. And even in its own domain, Woolley has been referred to as the Woolley exception for state interference with daily life activities. You get other abstention cases like Huffman and like Pennzoil that emphasize that we care about having litigants exhaust and go through the direct appeal, and we care and we think that state courts are competent to make constitutional law determinations. So I think they're in tension with other abstention principles.
So I don't want to put words in your mouth, but you're basically telling us that post-HEC and some of the other cases that come after that, Woolley is no longer good law.
I'm saying the inquiry is different, and it's not an abstention case. Woolley was looking at the relief that the petitioner said that he wanted, when HEC is looking at the implication of what would be held. And that's a big problem with all the questions, is that in the HEC context, we have never let a petitioner label around HEC. And just because a plaintiff says, I promise, I'm not going to use it to undo my prior conviction, we look at the implication of success in a 1983 lawsuit, not what a plaintiff promises. And that's my issue too with the government's position. I mean, they would say that somebody who is in prison could just say, they wouldn't say somebody could just say, I want to bring a pre-enforcement challenge and I promise I won't use it to try to get out of jail. But the day that person gets out of jail, it would be okay. And that would rewrite the indirect method that was recognized